mesothelioma. Since a 2020 Missouri jury imposed a multi-billion-dollar award against the leading talc manufacturer, Johnson & Johnson, the company has been served one or more legal complaints every hour of every day. Last year, Johnson & Johnson decided that rather than persevere under the uncertain risks of over 38,000 lawsuits, it would pursue settlement. In a series of transactions that are far too complicated to really get into today, a corporate restructuring placed talc liabilities in a new entity called LTL, which then proceeded to file for Chapter 11 protection under federal bankruptcy laws and proposed the creation of a trust from which those who claim harm from talc both currently and in the future can draw. A group of talc plaintiffs and a law firm sought dismissal of the bankruptcy proceedings, arguing LTL had proceeded in bad faith. The resulting court decision rejecting that motion to dismiss and its larger points about the difficulties of settling mass torts will be a part of our discussion today. Let me briefly introduce our panelists. Professor Samir Parikh is on the full-time faculty at Lewis and Clark Law School and is a nationally recognized expert on business reorganizations and mass tort bankruptcies. He has written numerous influential law review essays on the subject, including 3 for which we will provide links in the Zoom webinar chat function today. Prior to joining Lewis and Clark, Samir practiced financial restructuring at Latham & Watkins and Milbank, Tweed, Hadley, and McCoy. Sherman, also known as Tiger, Joyce, is president of the American Tort Reform Association and a member of the group's board of directors. Prior to assuming that position in 1994, Tiger worked for Senator John Danforth and was minority counsel to the Senate Commerce Committee. Finally, joining us today is Archis Parasharami, who is co-chair of Mayor Brown's consumer litigation and class actions practice. He routinely defends businesses and class action litigation at federal and state courts across the country, with particular focus on strategy issues, multi-district litigation, and critical motions seeking the dismissal of class actions or opposing class certification. We'll be happy to take your questions as we go forward in this program or during the end of the program. Please use the Q&A function at the bottom. And also just a reminder that we are recording this program. Tiger, why don't we get started with you? What sort of litigation situation did Johnson & Johnson face prior to pursuing this divisive merger solution?
Yeah, well, thank you, Glenn, and thank you for inviting me to participate today in the webinar. Delighted to be on with Samir and Archis, and I think they'll be the real experts. But you know, as part of ATRA's mission, we highlight what we think are the most significant litigation policy issues, and also those particular jurisdictions where we think the problems are the most pronounced. Webinar participants may be familiar with our judicial hellholes report, where we highlight you know, virtually all of those matters, litigation issues and venues that we think are of particular concern. And unfortunately, the talcum powder litigation that you discussed, and in particular, I would say the Ingham case coming out of Missouri, have been front and center in our report. And I think in many ways, it touches on a lot of the most significant problems with mass torts from the standpoint of defendants. And I think the decision last year to restructure and seek bankruptcy protection was, at least from our perspective, a logical next step. And certainly one that the legal system provides as a reasonable opportunity for a business under these particular circumstances. The talcum powder litigation, I think, highlights some of the most significant problems, whether, you know, we highlighted in amicus briefs, you know, on their various appeals, whether it's jurisdictional questions, whether it's just the fact that you had, I think, something like 10 different state laws were in effect in the Ingham case. As I recall, I don't have the details in front of me, but I think it took several hours for the judge to read the jury instructions. Just imagine yourself being a member of that jury, trying to understand all these different state laws, different sets of scenarios. But it's really the aggregation of claims in these mass tort cases, and whether it's talcum powder, whether it's asbestos, any number of litigation topics where there is strategic advertising being done both on television, radio, and also online. All of this contributes to the problem. And I think, Glenn, you highlighted, I think, what the judge, the bankruptcy judge said, which was really completely, I would say 100% on target about the frequency, the number of cases that they were facing. I think 1 an hour every day, 7 days a week, every day, every week of the year. Just the sheer volume of the lawsuits in and of itself becomes, I think, a highly problematic issue. In the commentary, the op-eds that we wrote about this topic, we argued that it in effect becomes a race to the courthouse. Who has legitimate claims and who has potentially put their chips behind a lawyer or a law firm that actually might be able to recover, as opposed to simply adding to this overwhelming aggregate figure of number of claims, which has, at the end of the day, I think the litigation experience is, I think, ironically, as we pointed out, I think the 3 most recent decisions prior to the declaration of bankruptcy had been defense verdicts. So I think there are a lot of matters that go into it. We've highlighted them extensively. And unfortunately for Johnson & Johnson, as well as others, these matters are significant challenges for defendants.
So as Tiger noted, Archis, the Johnson & Johnson did have some success just before they decided to move forward into the bankruptcy space. Talk a bit about what factors are most relevant to outside counsel, in-house counsel, senior executives when considering settling in those kind of situations, generally speaking.
It's a great question, and I think as outside counsel in these sorts of cases, our job is to help the business find a solution to a problem. And at a high level, this is largely a business problem that requires a business solution. And so, unsurprisingly, decisions whether to settle are business decisions. That said, I think lots of plaintiffs' lawyers would be surprised, or often surprised, to hear from me how much the principle does matter. And certainly in smaller cases, businesses will not necessarily settle just to avoid the cost of defense, although of course that plays a role. They do care about the merits of cases, and the lawyers who are in-house are people, and often are people who are competitors. They like to win, and they like to win, especially when they think they're right, and often they think they're right. But that said, that is, just because you're right, and I think Tiger talked a little bit about how in some of these cases, it was pretty clear that the company did win on the merits. Nonetheless, you have to account for other factors. So some of the questions are, what is the overall exposure adjusted for risk? What is the cost of defending against the litigation? And in looking at the opinion in connection with this bankruptcy, the discussion of the cost of defense were actually pretty compelling to the judge. Another question that I think companies ask is, well, what is the message that settlement sends? Sometimes settlement is clearly understood as a business decision. Sometimes, perhaps wrongly, it is read as something more, and that's a factor that I think businesses should think about. The existence of ongoing litigation can potentially be an enormous distraction for the actual business at hand. People who have their jobs to do to advance a company's mission can be asked to help participate in the litigation instead, whether it's providing evidence or discovery or thinking through the problems, or at the executive level. It's obviously not what they're there to do. So that's not desirable. And finally, is there a benefit to bringing an end to this thing? Is there a benefit to finality, to putting the matter behind the company, which clearly seems to be, and I'm not speaking from inside knowledge, but when you read the papers, you can tell that is animating what's going on in the case that is sort of our paradigm. I'll just deliver one final thought, which is that there are lots of cases that I think businesses could win if they litigated them all the way, but our system makes it too costly to do so. And a couple of factors are the American rule, which generally prevents cost shifting. And historically, and this is an issue that I think defendants are trying to work on, but the cost of discovery have been borne disproportionately by the defendants. And that's why, even though the merits of cases are important, they are frequently not the sole or even the primary driver of settlement.
Samir, you've done a lot of research on mass torts and those that end up in the bankruptcy process. Do you have any thoughts on that? Things that you've seen, trends that have led to companies to settle more often than not?
Yeah, and once again, thanks for having me. I think just really quickly, I would love to just lay the landscape a little bit out there. So I think when we see these cases, there's a lot of questions that arise. We have all these claims. So here in this case, we have, I would say, maybe over 40,000 claims. If you look at the 3M case, you're talking about hundreds of thousands of claims. And the question is, how do you aggregate these claims and ultimately resolve them quickly? And something I think we're going to talk about a little bit later, this idea of your day in court. Well, if you're one of hundreds of thousands of claimants, the chance of you getting your day in court is highly unlikely. And the reason is because, once again, because of so many claims, there has to be some mechanism to aggregate them efficiently. So, historically, we've had the class aggregation process under Rule 23. So I think most people who are seeing this, sorry if my volume's a little bit high, let me turn that down. I hope you guys can hear me okay. So the class aggregation process has oftentimes been seen as the gold standard and one that most people on the periphery are aware of. This idea of, you filed this class action and that gets resolved. It is seen as the gold standard in many respects. But the issues, we've seen this from Supreme Court jurisprudence, when you have individual issues regarding causation and damages, it's very difficult to satisfy Rule 23 stricture. So for most Mass-Tort cases, especially those that have future victims, class aggregation is not on the table. So then we get into this MDL process. And with MDL, that's usually not as well known by individuals. Sorry, I'm seeing that maybe my connection is spotty. So I'm not sure if there's anything I can do about that. Maybe I'll slow down a little bit and see if that helps. But so with multi-district litigation, the issue, there are multiple issues with that. So I think there's some debate about whether MDL was actually designed for this type of matter. And the main concern with MDLs is just that you can't get global settlement. So this dark cloud that's hanging over the company that Archis was talking about, the issue is that with MDLs, that cloud doesn't get removed because MDLs can't aggregate state court claims and they can't aggregate future claims. So future victims who've been harmed. Asbestos is the archetype, but we see in lots of other cases like the Takata airbag case. There are individuals out there who are going to be harmed. They don't know they're about to be harmed or it could happen in the future. So MDLs don't aggregate those individuals. So it sounds like there's still some static. Glenn, can you hear me okay?
We can hear you fine. There is some static.
Okay. I'm sorry. I'm not sure if I'm doing anything in particular that's causing it, but I'll have to. I guess I'll just move on and quickly just note that. So that's why you see parties opting out of MDL. There's lots of infirmities there. The thinking is that by opting out, you can actually regain autonomy over the process. So with MDLs, of course, it's protracted. You have a lot of these cases that drag on for 6, 8, 10 years. Settlement is oftentimes imposed by the court. You can't exit an MDL, and that's maybe one thing I should make before the static overwhelms me. If you're a party that is captured in MDL, you cannot exit. Victims can't say, I want to leave and have my day in court. The parties can't say, I want to leave MDL, I want to go do something different, or maybe settlement's just not appropriate. We've realized we just can't settle this. We're going to try some more cases. That is not an option. So that's the only option available for a party stuck in bankruptcy as a corporate defendant stuck in MDL is to file for bankruptcy. So that's what we're seeing at this level.
Just so I wanted to ask you to elaborate a little bit on what Samir said about class actions. It seems on its face that class actions would be a good way to settle a large number of cases, all involving the same general allegation and the same defendant or defendants. Why is that not the case? Does the Supreme Court have to say about that?
Yeah, and Samir alluded to this, and absolutely right that it's the product of Supreme Court precedent in this area. In a seminal opinion by Justice Ginsburg, 25 years ago, as it happens, the case was called Amchem Products versus Windsor. And I'll just give a little bit of background on that because I think it helps to see why the class device is not being used. I think if the class device were available, we would have a very different conversation on today's webinar, but it isn't available. What happened in AmChem was that the parties attempted a global settlement of current and future asbestos-related claims. They sought to use Rule 23b3, which is the provision for an opt-out class for damages. And they provided a detailed agreement that included an administrative mechanism and a schedule of payments to compensate class members who had met particular requirements. The district court approved the settlement over objections, but the Third Circuit reversed in an opinion by Judge Becker, who's one of the leading lights of the Third Circuit, and he concluded that the Rule 23's class certification requirements hadn't been met. The Supreme Court largely agreed. Justice Ginsburg said, you can take settlement into account in thinking about class certification, but not too far. And what the court ultimately concluded is that, and this is really at the heart of the holding, is that settlement classes still have to satisfy essentially the same Rule 23 class certification requirements that have to be satisfied for litigated class actions, with one meaningful exception, which is whether a trial of the action would be manageable. The opinion gets that since there will never be a trial, you don't have to talk about, could you hold a trial here? But everything else has to be satisfied. And once you get to that point, it becomes clear in cases involving personal injury, and especially, as I think Samir rightly pointed out, future claims, that it's hard to do that. And I think because it's useful to thinking about the problems today, I'm just going to tick through some of the asbestos issues problems in the asbestos-related claims that had caused the Third Circuit to say no way and the Supreme Court to agree. That class members were exposed to different asbestos-containing products for different amounts of time in different ways and over different periods. Some class members had no physical injuries or comparatively minor injuries. Others suffered from lung cancer or other serious injuries. Some class members had smoked, others had not. That affected causation. And there were some members of this class of this proposed settlement class that had not suffered any injuries at all, had just been exposed. So they were potential future injuries were on the horizon, but they didn't have them at the moment. And putting this all together in a way that satisfied the predominance requirement of Rule 23b3, and that requirement, just for folks who don't live it every day, is that common issues must predominate over individual questions. But the list of individual questions, which is really just a short list, there were more, right? And there often are more, really overwhelmed the common questions in the view of the court. And partly because of the way that there were both current and future injury class members, the court held that adequacy was not met because the interests of the class weren't aligned, and it didn't think that subclassing in that context could work. Sometimes it does, sometimes it doesn't. There's a big debate about how that works. There was a case a few years later called Archis versus Fiberboard, also out of the asbestos crisis. Same basic problems with individualized issues. The attempt was to avoid the predominance question by using Rule 23b1b, which is not a commonly used tactic, and especially not common anymore after Ortiz. It's the so-called limited fund mandatory class action, where there is a pie that's limited and everybody has similar claims that could be divided up. It works in some modest settings. The court held not in this kind of complicated setting where there were such disparate claims, and most prominently where the court thought a fund can't be limited by agreement of the parties. You can't say the fund is limited because we agreed to a limited fund, basically. And whatever one thinks of the law on those issues, I mean, I'm torn about it. As somebody who defends class actions, I like the rigorous implementation of Rule 23, but in the context of these cases, it basically has blown up the use of the class device for settling these sorts of claims, which is why you have the explosion of MDLs. That's not an accident.
The MDL process, Samir, Congress created it generally for the purpose of sending cases back to their original locations. for trial and for other things. It's mostly pre-trial, but it certainly has grown beyond that. What parts of that purpose make the MDL process especially unuseful or hard to use in these kind of global settlement situations?
Yeah, so it's interesting that I think there was some sentiment in the original design for MDL that it could be used to address these sprawling cases. But at least if you look at some of the structural design elements, the thinking was that you could have procedural streamlining in one court, and then cases would be returned to their original courts. And that really hasn't happened. So there's so many statistics about MDLs and how basically cases don't return to their original courts. They stay where they are. They'll drag on for years. We saw Judge Kaplan note this in the opinion that it had been 6 years, and we hadn't seen progress in the talc MDL. And that happens in a lot of these different MDLs. So I think in some respects, the idea with MDL was, of course, to have accelerated settlements or some sort of accelerated process, and that hasn't materialized. So, the bankruptcy, that's sort of the response to that infirmity, the idea that with bankruptcy, within 18 months, 24 months, 36 months, you could see a recovery. And I always go back to this when I talk about what's the objective of the process. I think the objective is to find a recovery for meritorious claims on an accelerated timeline. And if MDL isn't satisfying that objective, then it's worthwhile to consider other options.
So, Tiger, does the ongoing opioid MDL offer a cautionary tale for those who believe that MDL vehicles offer an effective way to settle lawsuits like this, many claims against the same defendant or defendants?
Well, I think, my co-panelists have highlighted some of the vexing problems of these Mass-Tort cases. I think there are a lot of smart lawyers out there on both sides who, if there were an easy path, it probably would have been identified and be utilized. But I think what we're hearing and what we see is that the MDL is another problem area. And I certainly, the last thing I would ever do is speak for the trial bar. I'm not sure that the trial bar necessarily sees it as a panacea, but I'll leave it to them, to individual or collective members of the trial bar to say that. We've talked about it a little bit, and I think the opioid scenario with Judge Polster, I think illustrates how difficult it is. Having said that, Judge Polster started out the process saying he was going to resolve the case. He was going to bring closure and finality to all of this, and that he kind of tipped his hand, at least from our perspective, that where he thought that the fault should be assigned. In thinking about this, we read, I thought, a very interesting law review article by two professors, Abby Gluck and Elizabeth Chambly Birch. I think it was published in the NYU Law Review, and there was a great quote that we pulled, which is that MDL's gravitational pull over thousands of cases demolishes all the normal expectations of individual process and federalism. And I think it really gets right to the heart of how do you resolve something where, in effect, the sheer volume is the overarching consideration and factor. Just to show, these are not professors that are typically sort of circling around ATRA events. I think Professor Gluck is now in the White House counsel's office. And so I think you would see a wide view that there are real concerns about opioids in particular, but the MDLs in general. But I think, wearing my ATRA hat, I would have to say that what we would take away from the opioid case, as much as anything about the procedures and the judicial issues, is this really shouldn't be a litigation issue from our perspective. These are enforcement issues. These are, when we look at the opioid litigation, I just have to say, there's every aspect of this is governed by the regulatory process, whether it's FDA approval and oversight and ongoing monitoring. It's the DEA on distribution, et cetera. And all of these efforts to look for a deep pocket, I think find their way into the court. And I think that if we can address that and the circumstances when that can or should not take place, I think that might be a good approach, and ferreting out the cases that don't have merit or that should be dealt with in other contexts.
So Samir, what does the Chapter 11 process offer to debtors and creditors that judicial processes like MDL and settlement classes don't?
Yeah, I think the global settlement is the most attractive piece. The idea that it's not just federal claims, it's state claims, it's not just current claims, it's also future victim claims. So you can marshal all those claims and get a global settlement. And that is extremely attractive. So, and I think that most people are sort of aware of this idea that if you are a corporation and there's a black cloud hanging over your operations, that affects investment dollars, it affects your borrowing capacity. So with the MDL, it's a half measure. You may be able to address some of the claims, but there's still a large amount outstanding that have to be addressed either through subsequent MDLs or subsequent processes. So bankruptcy offers that ability to address everything. And that, of course, is extremely attractive. Also, my argument is it's actually good for victims because there is this possibility of a global settlement. Parties are particularly focused and attuned in achieving that. And my argument is always that for certainty, the idea is that parties will overpay for certainty and finality. And I don't have any data on that. It's hard to, of course, quantify that and engage in empirical research, but that's always been my suspicion, that parties are willing to overpay for finality. So that's good for victims. Also, the process is extremely accelerated. One thing that I think it's a double-edged sword, but in bankruptcy court judges can estimate future claims and current claims. And they can say, okay, let's say there's 40,000 claims out there. And they'll hear experts from various parties, and they'll say, okay, we think the aggregate value of these claims is approximately $6 billion. Now, the court is not forcing that assessment onto parties. Claimants have a right to vote on whatever treatment they receive, but this is a starting point for the debtor. So the debtor can formulate a settlement plan and then propose it to victims groups. Victims groups like it, they can vote for it. Like we saw in Purdue, 95% of victims voted in favor of that settlement, which included the Sackler releases, which I think most people were offended by, but was necessary to get the deal done. And now parties, if claimants and victims don't like the terms of the settlement, they can vote it down. To the extent that that sort of rejection occurs multiple times, then there's a process by which the bankruptcy court may actually push that case out of bankruptcy, which is a disaster for the corporate defendant. So there are incentives there. There are the structural safeguards to protect these interests. So those are probably the big pieces. There are lots of other pieces involved. I've already noted the releases that are available to various parties. That is, of course, receiving a lot of attention right now. But the reason the releases are important is because you're providing them to various stakeholders who are providing funds to the settlement trust. So whether it's an insurance company, or whether it's an affiliated party, to the extent that they are writing a very large check to fund this trust, in exchange, they get a release, they get immunity. And that's being debated right now at a policy level by various people in various institutions. But that's how Purdue gets done. Outside of bankruptcy, you're not going to see that kind of recovery for victims. And you see this in a lot of different cases, and we'll see this also, I imagine, in the Talcum case, that J&J may contribute some money to get a deal done, but they'll want a release in exchange for that. And the question is, can the bankruptcy court give that?
One of the things that Judge Kaplan noted in his opinion was that the litigation process takes a long time, and it may be that some of the victims who are currently suffering from cancer or mesothelioma may not see the end of the litigation process, and that the bankruptcy approach at least gives them an opportunity to become whole immediately or more immediately. What are your thoughts on? Is that something else that is often taken into consideration when it comes to Mass-Tort and bankruptcy?
Yeah, probably that. There's probably two pieces there, right? The lottery effects, and Archis already mentioned this. If you're trying cases in various types of venues around the country. Sometimes it's a $2 billion judgment, sometimes you don't win. So that inherently is inequitable. Right? I mean, I call that lottery effects. Like, who knows if you're going to win? It's very hard to say in these cases, especially where the scientific assessments are unclear about whether talc actually causes ovarian cancer. There's definitely splits in these studies. So one thing that bankruptcy is offering is sort of smoothing those discrepancies. So victims groups are receiving recoveries based on their injury. They're being categorized. There is some assessment of merits, though that is de-emphasized, which a lot of insurance companies don't like, and we're seeing that right now with Boy Scouts of America. But the point being is that the bankruptcy process is trying to smooth these recoveries, trying to make sure there aren't outliers where some individuals are receiving a lot and others are receiving nothing. And then, of course, affording these payouts on an accelerated course. The idea is that within maybe 24 months even, payments are starting to be made. We know in the MDL that is not going to happen. That could take a decade to start getting those payments out. So yes, absolutely, that's a big difference.
So given all these benefits for claimants, Archis, why is the official committee of talc claimants at a law firm opposing the bankruptcy?
Yeah, and so I'll just provide my speculative view of what I think is really going on, and I think at bottom, it's about settlement leverage. If you look at the various tools that both defendants and plaintiffs can employ, and obviously bankruptcy is the tool or a tool that the defendant is deploying to alter settlement leverage. The plaintiffs don't like it because it alters the settlement leverage, or I should say the plaintiff's counsel. And I think that actually that dichotomy is important. And I am not casting specific aspersions on any particular lawyers, but just kind of from where I sit as somebody that defends businesses, you often see at least incentive structures in the law to have there be divergence between the incentives of plaintiffs themselves and their counsel. And I think in a setting where, like class actions, mass torts have the same problem, that the individual litigants are not really active participants in the cases. It's hard for them to be, so they have to put their trust in and have the lawyers kind of direct what happens. But the lawyers, at least as an economic matter, have their own incentives, and there is a value of one's time. Everybody can agree that you'd like to be paid more for your time rather than less. And it does seem to me like at least some lawyers, and I'm not necessarily talking about the lawyers in this case, but would rather roll the dice on the lottery effects Samir described, hoping to get a handful of outsized jury verdicts that then come with a large contingency fee. That's the structure of how that works. And more money sooner is generally better. I think that's just an economic fact. And I do think that is a little bit of what animates things here. And it is to be distinguished from what I think in the opinion from the bankruptcy judge. I read that as if you step back from the law and thought about policy. I don't know if we should or shouldn't, but let's just say that's what we did. I read his opinion as being about delivery of benefits to the potential victims, leaving aside whether the truth of the allegations, but and then also some sort of distributional fairness, that it not be lumpy in the way Samir described. $2 billion here, zero there. Is that as a whole, or is the group better off? I think this judge is saying no. I think at least some of the plaintiffs think, well, that's not the way we're thinking about this. We're thinking about people have a right to be heard on their specific cases, and let's see what happens. And that bankruptcy is depressing the overall size of the pie. I'll say like one thing that I found pretty interesting was that there were Canadian class plaintiffs who filed in support of the bankruptcy petition. They opposed the motion to dismiss the bankruptcy. And what they said was, this court provides talc creditors, certainly unlike and to a greater extent than any other court, the tools to best maximize efficient and equitable pro rata recovery for all creditors. But one thing that I thought was pretty interesting was, and the brief pointed this out, was that In Canada, mass torts class actions are the norm because Amchem and Ortiz aren't the law. The law is different there. And so they actually have a class, sort of a corpus ready to go. And I do think that is, kind of shifting the way they approach things, because I think they think that their class loses out entirely in a world where money is being dissipated slowly through the MDL process.
Tiger, there have been a lot of punitive damages claimed in the cases as they were going through the courts. The Ingham case you were talking about, there was a very large aspect of that was punitive. Is there a sort of underlying objection to the use of bankruptcy that corporations are getting away with something that they're not being adequately punished for what the plaintiffs and the plaintiffs' lawyers see as itinerant behavior?
Yeah, I think that's definitely in play here, underlying a lot of these lawsuits. I think the talcum powder case being a perfect example. And I think it just ignores a lot of different, in effect, I would say, sort of facts on the ground. I think earlier, I don't know if it was Archis or Samir, talking about, that this bankruptcy process, that this judge is obviously looking very carefully at the whole scenario, but the creditors vote. If the situation doesn't look equitable, the creditors can withhold their support and it won't move forward. So I mean, we tend to kind of forget that. I think there is and I'm going to probably regret saying this, but there's this romantic notion that everybody has to have their day in court. But as my colleagues have been saying, that's a virtual impossibility just with the sheer number of cases. And I think that if you think of the bankruptcy process as a resolution technique, after 9/11, we didn't have litigation. There may have been some, but as a country, we came together. We had and can still do a settlement fund. There are different scenarios for resolving claims, and I think that when we look at some of the overarching policy and legal considerations and matters that are of interest to us at ATRA and in the civil justice reform community, we would call what we say sort of nuclear verdicts, these excessive awards. And a lot of that is brought about by converting the process of what's intended to compensate people as in for the most part into this sort of punitive arena. And then, the final thing that I would say, I would note with a little bit of irony, at least from our perspective, when you look at our judicial hellholes report, one of the overarching questions is, and you heard both of my colleagues on the panel talk about, the $2 billion case in one instance and a defense verdict in the next, where the cases are brought is a policy issue that we've been focusing on. The U.S. Supreme Court has issued opinions on, and I think even in the U.S. Congress in discussing the bankruptcy issue, there were some pointing to the fact that, well, these companies can choose where they seek bankruptcy. In effect, they're forum shopping. I thought, well, maybe there's been a conversion to the recognition that, where a matter is brought is a relevant policy issue. But I think back to your original question, we refer to it sometimes as sort of the reptile theory, that you're not putting the matter under, under the microscope, but the defendant, and this is a defendant, a company that needs to be punished. And I think it takes advantage of, common views held around the country, in particular in jurisdictions where, we would say in our Hellholes report, favorable verdicts and rulings are the norm and not the exception.
And Glenn, could I just piggyback on that? And Tiger made a lot of good points. I would like to say that bankruptcy certainly has a PR problem. So I'll start with Purdue just very quickly. So the Sackler families get releases. Those releases are very broad. The optics are terrible. These individuals, what they're involved in was pretty despicable. Even counsel, Marshall Huebner was lead counsel in Purdue, and things he has to say about the Sackler family are terrible. He hates them, everything they did. But why they get releases, right? So the optics are terrible. on the release. But the reason the releases comes about because you need them to kick in money for the settlement trust. Keep in mind, victims voted 95% in favor of that settlement trust and the terms of that settlement, which involved the releases. So the optics are terrible, right? But the truth is you don't get those funds without the releases because statute of limitations and all kinds of issues that go into it. People focus on the dividends that the Sackler family released. Most of those funds were used to pay taxes. You're not going to get that money back from the government. So that's a big point. Also, the day in court ideal. I know I've talked to a lot of journalists about this. They mentioned a lot. I can't stress it enough. You're right. Victims do not get their day in court in bankruptcy. That is true. Victims also do not get their day in court in the MDL process. That is true. There's bellwether trials. There's a couple of select representative victims who may be selected to be a part of it, but no one's going to get their day in court. So that's not a possibility either way. Even if the J&J case is dismissed, no one's getting their day in court. So we just have to accept that. Another thing I just want to note is that the divisive merger, J&J did this Texas two-step. Once again, optics are terrible. I'm not sure exactly. I understand why they did it, but I don't think they fully appreciated the blowback they were going to get. And they probably could have done it without the Texas two-step. The reason they did it, they didn't want to disrupt the other pieces of the empire, and I get that. But it just looks really bad that this company that, of course, it has better credit rating than the U.S. government is taking one of its affiliates and doing this elaborate process and then dropping only a subsidiary that has the bad assets and not the good assets into bankruptcy. I think we're going to talk about that in a second. But once again, I think bankruptcy has a PR problem, and I've been trying to explain why these things are happening. But I understand why the general public is sometimes confused when they see these cases.
Archis, is there the objectors to the creation of the bankruptcy raised the Seventh Amendment issue here, sort of harkening back to the day in court sort of idea? What did the judge have to say about that, or were you surprised by how curtly he addressed it?
I guess I wasn't, because to his credit, he didn't brush it aside. He said, yeah, that's an issue, but that actually the way that these trusts work out, you can opt for a jury trial. The one thing that is a feature of that is that both the potential size of the recovery is capped, and the timing of those recoveries are capped. I haven't thought it through fully, but my sense is that I don't see how the Seventh Amendment itself guarantees any specific level of compensation or punitive damages. And I think, and Samir is clearly the expert on bankruptcy law, but Congress as a broad matter can even legislate out of existence pending claims. So the idea that claims could be capped doesn't seem to run into constitutional problems from my perspective. Stepping back, I think that if there is a world where juries are determining liability in some circumstances, but that the allocation of the overall fund has management by the bankruptcy court, that's a good balance. And then I think the most important point is the one that I think everybody has been talking about. Tiger said it, Samir said it. The day in court it is part of who we aspire to be. I mean, I understand that concept, and in practice, it in MDLs does not exist. It does not exist for almost anyone except maybe in the bellwethers. I'm sure I have some claim in life that in theory could be part of an MDL. I promise you, if I were the one who filed it, I would be waiting 10, 15 years or never. And indeed, the bellwether trials are not really trials to give someone their day in court. They're in practice, what they are is test cases to help gauge the value of settlement. So yeah, and there's a lot of, I would say, I don't want to say manipulation, but I would say negotiation over how to have these bellwethers take place to try and engage in an estimate. But the idea that citizens are getting their cases heard by a jury via the MDL process is just not so.
So let's assume for the moment that this bankruptcy trust it goes forward. Samir, how will the trustees determine which individuals merit a recovery from the trust?
Yeah, so generally speaking, with a lot of these trusts, the level of discretion afforded the trustee is limited. And this is something that we're seeing in the Boy Scouts of America case, where the insurance companies are claiming that there are a lot of fraudulent claims here. and there has to be a process by which those claims are ferreted out. But the truth is, with bankruptcy, we don't see that type of design element in a lot of these trusts, because the thinking is that the sheer number of claims, the sheer volume of claims has overwhelmed the system. So there has to be a very simple way to streamline the process. So on the back end, what's happening is that there are certain qualifying factors that the trustee is looking for. Once those factors are apparent, then the trustee is quickly moving to a categorization. There's different categories, and depending on how these claims are categorized, then there is a payout attached to that. So a simple one would be the type of injury suffered. As Archis mentioned, asbestos is an example, but there's lots of other examples out there where, in some cases you could have a severe injury. In other cases, it could be more moderate. And so that categorization is occurring just to provide a payout. So it's almost like a formula. Great, some qualifying factors, we check those boxes. Great, you're in this category. If you'd like to dispute it as a claimant, you can, and you can technically opt out. But at that point, your recovery is capped. You could go to court and, I guess, quote unquote, have your day in court, but your recovery is capped. That's another interesting aspect of the trust that I think sometimes doesn't get discussed.
It's like the concern with fraud and the number of claims that are brought into the bankruptcy trust that sort of erode other people's recoveries has come up quite often in asbestos. Can you talk a little bit about that?
Yeah, I happy to, and I think I would just echo what Samir just talked about. But I think that we have seen clear issues in the past, especially in the asbestos area. I think there's actually a timely analogy right now where it's actually the LLC that was formed by Georgia Pacific as part of their bankruptcy, this so-called Bestwall company. And so they've gone through this process. This is about about 5 years ago. But as part of the process of resolving these claims, determining payouts and so forth, the bankruptcy judge in Charlotte, I think her name is Judge Laura Beyer, is actually now fining per day individual claimants, which is, you have to say is fairly controversial. But the reason why is because they are not providing information to the process in terms of other payouts they've received from other trusts. So the transparency issue is really the, sort of the overarching issue. And this goes back even further, I think in a decade or so ago or more, to a case involving Garlock. And there it was determined that there was fraud committed in terms of allegations of which particular company had actually had a legitimate, or to which company or trusts and their predecessor companies had there actually been exposure, and the whole transparency issue arose. And this judge, I think, made an interesting observation, at least what the reports that we have seen, which is this is not based on, a group of individuals making this decision. It was law firm by law firm. So it was a strategy being used by the firms representing individual claimants against this one particular trust. So the transparency issue, we've seen legislative reform around that, around the country in terms of requiring a claimant and his or her lawyer to disclose, in effect, kind of, I would say, you could almost say in a simplistic way, a collateral source rule type of procedure for taking place within the bankruptcy process. But I think it's important because, I think past is prologue, and I think whether the J&J, the LTL matter does proceed or not, these are the kinds of challenges I think that any successor, any future trust will likely have to encounter.
Samir, is there going to be, or you think there's a possibility of some sort of safeguard against those who are claiming mesothelioma that may have drawn from another asbestos trust that prevents them from going in and trying to draw from the talc asbestos trust? This is an asbestos trust after all.
Yeah, no, that's hard, right? And I just echoing what Tiger's point, the idea that when you have these fraudulent claims, remember it's harming victims. The interested parties, the corporate defendant, the insurance companies, affiliated parties, they contribute into the trust and they walk away. There is no recourse. There's no contingency where could be forced to contribute more funds to the trust because it's underfunded. And this is something I think also doesn't get discussed very often. There is absolutely no backstop to the trust. If it fails, it fails. Full stop. Court can't go after. Let's imagine J&J puts together this trust. You can't go after J&J after the fact. They have full immunity, full releases. Any insurance company, any affiliated parties, even if assets were sold to some other entity, they have successor liability claims. Those don't exist. So the trust is a standalone. So that's why this idea of fraudulent claims actually is really important for victims. If there for some reason is too many fraudulent claims that had not been properly anticipated, it could overwhelm the trust. And that just hurts future victims. If you have a meritorious claim, you pop up 10 years down the road, the trustee may say, sorry, too many claims. Maybe we misjudged it. Who knows? Maybe a lot of them were fraudulent. My job isn't to assess them in the way that perhaps a court would. So the trustee is maybe writing checks that maybe he or she should not be writing. Is there a way to police that? I don't know if there is, because once again, as we talked about, the sheer number of claims, the sheer volume sort of eliminates that possibility. I'm sure if the debtor was extremely fixated on that possibility, they could structure the trust in a way to limit the risk, but I have not seen any trust designed that way.
And Glenn, can I just say
Absolutely.
to echo Samir's comments? I mean, I think this really gets back to what the judge said about this entire process. If you can sort of get past a little bit of the hot rhetoric, that's really the issue here. If there really are legitimate claimants, people who can demonstrate injury and it's appropriate, for them to recover via this process, then the fraudulent claims, excessive claims, all of that comes at the expense of others, and we have to keep that in mind as we contemplate individual cases, as we discuss what the appropriate policy is. I think that the discussion that we have seen in the public debate about bankruptcy, I think Samir said it very well. Bankruptcy, which is not certainly anything, I am anything but an expert in it, and my organization is only focusing on it in this context. But I think that we just can't get past the hot rhetoric, and that's what we have seen to date, and that by doing this, that in effect the suggestion is that it's inappropriate, and it circumvents the legal process when obviously it is a legal process, and I think that it would really behoove policymakers to really look at this from the standpoint not of the hot rhetoric, but rather of the way to appropriately resolve claims.
The word that I'm sorry, go ahead, Archis.
Oh, I was just going to say, Tiger made a point that I think is worth underscoring, that outside this bankruptcy context, in MDLs, the problem of false or fraudulent claims is actually an enormous problem, because the methods of aggregation of essentially signing up clients, this phrase inventory is used a lot. It's an unfortunate word to use about people, but what you see is large numbers of claims that have not been thoroughly vetted. And I think it's sort of obvious why defendants are concerned about that. It is unfair to defendants to have claims that are illegitimate. But the point that Tiger made, and I think Samir made this too, which applies equally in the MDL context, is it's also unfair to legitimate claimants because their claims are being diluted. In the end, these cases are going to settle, if they settle, for some particular pie. And if there are too many claimants with unfair claims, that reduces the payout for people who may well be much more deserving.
Yeah, one thing if I could just add to that, I think my organization has done a lot of analysis of the advertising that goes into creating this volume of litigation, because I think both my colleagues are exactly right. It's just the sheer volume which becomes the driving force. Just as a silly analogy, I had a conversation not that long, well, now I guess a couple of years ago with a friend who's a cardiologist, and he had read an article about a huge settlement involving Xarelto and something that he, as he said, he prescribes to his patients. And I said to him, you know, you're shocked at how high the settlement was. I said, that's a settlement that was reached after the defendants have won all the cases. You can imagine what the settlement would have been had they either gone batted 500 or even lost all the cases. So, you know, it really does. We can't lose sight of the fact that the sheer volume of litigation, you know, really is what drives so much of this beyond, as my colleagues have said, the merits and the procedures.
So one more question for Samir before we get into the audience's questions. The bankruptcy that we've been talking about today it's being pursued under a specific section of the Bankruptcy Code 524G because it's an asbestos trust. You've talked about the Boy Scouts and the Purdue Pharma. Those are proceeding under different sections of the bankruptcy, and what sort of provisions are available to asbestos bankruptcy pursuers rather than those that are not?
Yeah, so just very quickly, 524G was the statutory provision designed to address asbestos cases. It's only available for cases, once again, where there are pending asbestos claims, which would appear to capture the J&J talcum powder case. Keep in mind, though, some plaintiffs are alleging that talcum powder, when inhaled itself, can cause cancer, even if it is not tainted with asbestos. So we make it a really interesting dynamic. And to your question, so under 524G, there are very strict procedures in place to resolve these types of cases. And it offers a lot, but it also demands a lot. So what's being offered? This settlement trust, a channeling injunction, channeling claims away from certain parties who are receiving releases and immunity in sort of for amounts or contributing to the trust, right? That's the trade-off for 524G. But there's a lot of procedures in place and a lot of limitations. For example, when victims classes are voting for the plan, you have to secure at least 75% of consent in order for that class to be deemed to approve the plan. Normally, it's just a majority. So 524G applies a more stringent standard. There's also some restrictions on releases that become relevant in a variety of cases. Now, for a lot of the new cases we've seen, these modern Mass-Tort cases, whether it's Purdue or Boy Scouts of America, USA Gymnastics or Takata, they don't have asbestos claims. So what they've basically done is they've cherry-picked the good things out of 524G and left all the bad things. And basically that the bankruptcy court can approve that through powers they have under Section 105. There's basically their inherent inequitable powers, as it's called. So yeah, it's a little more flexibility. And there are some concerns that have arisen because of that. We haven't seen any of those really come to head in any of these recent cases because, as I mentioned, so when we look at these recent cases, victims are overwhelmingly approving the plan in amounts ranging from 90% up to 95%. So we haven't had an issue there where suddenly, oh, do you need a majority vote or do you need a 75% vote? Also, in terms of the releases, just one final piece, the releases are easier to secure in the modern cases because the standard is lower. Basically, any sort of significant contribution to the trust would be sufficient to gain a release, assuming bankruptcy courts have the power to grant these releases, which I think, as we all know, is being hotly debated. The Second Circuit is going to be ruling, I think, any day now. Any day now. They promised something towards the end of April. So we should see a ruling from them regarding whether these releases are permissible.
So that should ask a few of the questions that we have from our online viewers. If you have further questions, don't hesitate to type one in. One is, can you discuss ring fencing, the practice of private equity to buy liabilities and insurance proceeds as a mechanism for companies facing significant Mass-Tort liability to find a way out of litigation? I open that one up to anyone who might have knowledge.
Not sure I could offer much thought on that, I have to say.
Yeah, that's a great question. I have not looked into that.
Okay. Another question, has the plaintiff's counsel filed an appeal of the bankruptcy's court judge's decision?
Yeah, my understanding that appeal will be coming. The question is, exactly where will it go? Probably go to the district court. though there could be a request to maybe fast track it to the circuit court. There's no BAP, there's no bankruptcy appellate panel in that circuit, which is in some circuits, and that panel would normally hear that appeal. But my understanding is yes, it will be appealed.
So the case started in North Carolina, Samir. Why did it end up in New Jersey?
So this is part of the divisive merger we didn't get a chance to talk about, but basically you through this divisive merger, this Texas two-step process, a company can be split into two, and good and bad assets can be allocated freely. So that's basically what J&J did. They reincorporated their sub in Texas. They created these two entities. Good assets went to one entity. Bad assets and liabilities went to LTL Management. Then LTL Management reincorporated in North Carolina. That had been a very favorable venue for these types of cases. And Jones Day, who is probably deserves some credit or blame, I'm not sure how you want to characterize it, but they were sort of the originators of this very creative, some potentially questionable process. And they had success in North Carolina. So they filed there. But the judge there, and also I was contacted by Shelley Abel, who is basically the U.S. trustee there, and they had been reading the headlines, and they had lots of concerns, and they were worried that perhaps their court was being in some respects exploited or manipulated. So they asked a lot of questions, and the answers that came back was basically, we have an MDL in New Jersey. This case should be in New Jersey. There may be some coordination necessary between the bankruptcy court and the district court. That could be facilitated if they were in one jurisdiction. There are obstacles down in North Carolina. Also, there was no relationship to North Carolina aside from the fact that LTL had merely incorporated in that state the day before they filed for bankruptcy. So I think that was really the basis for the transfer.
So what happens when this goes on appeal? Do all of the lawsuits that would eventually be brought into this process, do they remain stayed, or as well as the ideas of how to manage and create the trust?
So Glenn, you're just asking in terms of J&J, this case, and it's currently in bankruptcy. It's on this, the judge's decisions on appeal. I imagine it would not be overturned. I imagine that'd be highly irregular. I think these are significantly complicated bankruptcy issues. I think Judge Kaplan did a great job explaining why the case deserves to stay in bankruptcy court. While this case, of course, is unfolding, there's an automatic stay that prevents any sort of other creditor collection action, which would capture litigation across the country. I know there was a question, I was asked to submit written testimony to Congress a couple months ago, and one of the questions was, well, this doesn't seem fair. Why is this automatic stay halting all this other litigation across the country, litigation that doesn't even involve LTL Management directly? And the reason is because bankruptcy is essentially a settlement process. The automatic stay is supposed to halt all these distracting events, allowing key parties to focus on settling the main case. So keep in mind, when we have these, sort of one-off rulings across the country, it doesn't move the larger case to settlement in any way. So the thinking is that halt all those proceedings that are distracting key parties, let them focus on settling the main matter, sort of essentially, curing the disease instead of addressing all the symptoms of the disease. That's one way to maybe look at that.
So cases both in federal and state court are being
Exactly.
stayed.
Yeah, exactly. Automatic stay can halt all those proceedings.
Which I think raises a more interesting question as well, but we are pretty much out of time, so I won't dig into that at all. Tiger, Archis, thanks very much for joining us today. Samir, really appreciate you bringing your expertise to bear. You really, I think, found an interesting area of law and policy to research and write on, and I hope you continue doing that. Thanks everyone for joining us today. And this program, as I said, is being recorded, so it will be available as an on-demand file on our website and in our YouTube site later on today. Thanks again, gentlemen.
Thank you.